We believe that the child is being employed by his father in order to take care of his father.
That's one-sided bluster.
Todd's a really nice guy, and he's just, hey, I get along with him, everything, and then I mean, just rip out the throat.
My client was made aware that there are allegations that Paisley had been molesting the girlfriend of the plaintiff's son.
This matter is before the court on the plaintiff's motion for temporary custody, parenting time, and support. Ms. McNeff.
Your Honor, we were thorough in our motion regarding the difficulties with Mr. Scobie's health in terms of taking care of his 6-year-old. It's my understanding that Mr. Scobie was hospitalized until last Wednesday, and upon leaving the hospital, went and picked the child up from school and kept the child. There was some police involvement at that point. We do not believe that Mr. Scobie is capable of caring for this child on a full-time basis. It's further our understanding that Mr. Scobie recently acquired a cat, and when Ms. Scobie asked him how he was going to take care of it, his reply was that he was going to have the child take care of the cat, clean the litter box, feed the cat. Our position is simply that Mr. Scobie couldn't take care of himself without the assistance of Mrs. Scobie in terms of dressing his wounds, which are significant, and making sure that he had the antibiotics he needed for ongoing infections. And we think it's absolutely inappropriate for him to be attempting to care for this child. And in fact, we believe that the child is being employed by his father in order to take care of his father, which is not, if the child were 16, maybe that would be a little bit appropriate, but at 6, with the child being in, the child isn't even in 1st grade, the child is in kindergarten at this point. We don't believe that this is an appropriate placement for the child, and we would ask that the court grant Mrs. Scobie the temporary primary physical custody and sole legal custody of the child, and provide Mr. Scobie with appropriate parenting time. Although we are concerned about even overnights with Mr. Scobie's health. If something happens to him, the child is going to be put in a bad position. We understand that the child, when Mr. Scobie went to the hospital, the child sat in the ER with Mr. Scobie for an entire day, which again, this is not an appropriate place for the child.
Okay. Mr. Scobie, what's your response?
That's one-sided bluster. She has me painted as an invalid, which is not true. I took wonderful care of him for the first 46 days that she left. Yes, I was in the hospital, but I had his 4th counseling therapy session scheduled for Wednesday. So the doctors worked with me. I got out, I picked him up, I took him to his therapy. Jamie called right after we got out of the therapy, which was unsuccessful because he was so tired, and said, I want to take Jaden. And I said, no, he's tired. He spends almost 3 hours in the car on a daily basis to get to and from school right now. And when I picked him up at school, he was so tired, he fell asleep in the car. He tried falling asleep at the counselor's therapy session, hugging me and grasping me. So my full plan was to take him home. And Jamie called, asked where I was. I told her. This is a therapy session that she was invited to, but as per texts that I have here with me in the truck, she will go nowhere with me, even if it's concerning the son of ours, which is strange, but. So anyway, I said, Jaden, your mom wants to pick you up, so we're going to meet at McDonald's. And he said, no, Dad, I want to stay with you, which is normal. He hates the discord, the confusion, and the pandemonium wherever they might be staying that night. Sometimes it's her grandma and grandpa's. or her mother and father's, and sometimes it's her brother's Dale's. And at her brother Dale's, there are 5 additional kids. No, there's more than that. There's 7 kids. And he hates the pandemonium. He has a tremendous conflict with one of his cousins that punched him in the face. He exists up there when he is there by avoiding his cousins. So we got to McDonald's. I have it all on video. And I told her I was videoing it. She had previously told me to call her attorney, which I did. I called Miss McNiff, and I explained what was happening. And I asked her why she was capable or qualified to make a determination on my health, mobility, and ability to take care of a 6-year-old. There was a 3-second pause. Obviously, she realized she didn't know me, and all she had listened to was Jamie. So I asked her if there was any court order requiring me to turn her over, and she said no. And I said, well, then I'm going to make a parental decision in the best interest of my son, who is tired and hungry. He needs a good night's sleep, and he's going to come home with me. And she didn't have a response to that, so we went to McDonald's. Jamie pulled in, and I said, look, Jaden, look who's here. It's your mom. And he turned away from the door. And his mom opened the door and said, come on, Jaden, you're going with me. And he said, no, I want to stay with Dad. And I said, Jaden. And he said, no, I want to stay with you, Dad. Previously, I'd been working with him to go up there because I want to foster a better relationship than he has with his mother right now. So I've been offering week on, week off. And in Jaden's world, that moment in the truck, he said, I want to stay with week on, week off. One day at Mom's house, and then a week at your house. And then one day at Mom's house, and then a week at your house. During that conversation, which I have videoed, she orders him to get out of the truck 2 additional times, total of 3. And he says no. And I said, Jamie, I'm going to take Jaden home and give him a good meal and a good night's sleep. Bear in mind, Jaden gets up at 5:30 in the morning when he is with Jamie, drives to Marshall High School with his step siblings, or half siblings, I guess they would be, drops his oldest stepbrother off, and then drives to Marley and sits in the parking lot for an hour before school starts. That's in the morning. After work, 2 nights a week, Jamie picks him up after school when it's her week, takes him to work where Grandma picks him up, where he may or may not spend the night at Grandma's. I got the inclination that he wasn't supposed to tell me, but he said yes, he did spend the night at Grandma's. And then other nights he spends with his uncle, aunt, and Jamie if she's there. So the custodial environment has been established. There's no doubt I can take care of him. I'm thoroughly convinced she has other motivations for wanting him. But Jaden wants to stay with me. It's where he gets the best care, the most sleep, and the most attention. Further, at wherever she's staying, she has 80 chickens, turkeys, geese that she removed from the farm, which, I don't know, I thought was community property.
Okay, sir, let's wrap it up. I got a lot of hearings.
I'm sorry. Anyway, she left him. I took care of him for the first 46 days. We're trying on and off weekly. I have no limitations, and he spends more time with me than Jamie. So I don't think we should upset this until the friend of the court actually gets involved and does their investigation. That's my recommendation, but you are the authority, sir, and you know the law better than I do.
Your Honor, may I briefly respond?
Yes, you may.
Your Honor, my client does have stable housing. She is residing with her brother. It's an absolutely appropriate environment for the child. My client was not involved at all in the decision to take the child to counseling and isn't even sure why the child is in counseling and would like to have that information. Given the allegations from Mr. Scovey, I would suggest that a preliminary evidentiary hearing would be appropriate pursuant to Sanchez versus Healy, which was a 2024 case, and Daly versus Ward, 501 Mich 897, 2017. I think that this should be an in-person hearing so that the court can better understand Mr. Scovey's physical limitations and so that the court can actually have the opportunity to assess both parties and their demeanor and their physical abilities while they're in court.
Okay, well, any, I guess, truth, Ms. McNiff, to what stated by defendant that they have been alternating weeks?
They have been, Your Honor, and a lot of that is because Mr. Scovey is a very aggressive individual. When I spoke with him, he was very aggressive with me. He's very forceful. He's very adamant, and there's a big age difference. There's a big disparity in the ability to control the situation. Mr. Scovey is certainly using a lot of coercive control over Mrs. Scovey. She's afraid of him, and so she has been unable to push back on his demands with the child.
Okay, well, at this point, if the
Your
parties-
Honor.
No, I don't need to hear anything else.
Okay.
If the parties have been alternating the weeks, we'll continue that till we have an evidentiary hearing. The court will try to expedite that, but I won't be able to get that in person until probably sometime in early December. But we'll be in touch with Mr. Scovey and with Ms. McNiff to see what works into the schedules. I do note there was another issue in this matter as it related to the support, and apparently that the defendant was collecting Social Security disability on Ms. Scovey's other 3 children. Is that correct?
That is correct, Your Honor. It's my understanding that there were issues getting child support from those children's biological father. And so Mr. and Mrs. Scovey petitioned it to include them under Mr. Scovey's disability payments. We don't think it's appropriate now that the children are no longer living with him, that continue. And with regard to the disability payment that the party's minor child has, I can include that in any child support calculation in order to determine what's appropriate with regard to that.
Okay, well, as it relates to the child of the parties, the court would order that disability payment would be divided equally between the parties until we have our hearing. That if he in fact continues to receive the disability on the other 3 children, that would be provided to plaintiff. But I don't think now that they're not together whether he would be getting that money. But if he does, then that would have to go to the plaintiff who has the care of the children. And we'll just continue that until such time as the hearing. So Ms.
Thank you.
McNiff, if you want to do a temporary order, at least, pending that particular hearing.
I will do that, Your Honor. Thank you.
Okay, thank you. You're free to go. Have a good day.
What's my understanding that I picked Jaden up after school?
Well, what you're going to do is you're going to alternate your weeks. So whatever date that the 2 of you have agreed to alternate, whatever day you agree, that's when that would start.
Tuesdays.
Would alternate the weeks until the next hearing.
Tuesdays. Okay, thank you, Your Honor.
Okay, thank you.
Sorry, I bugged out a little quickly.
All he stated is that the parties were exchanging the child on Tuesdays after school. So I said, okay, we'll continue what you've been doing.
Okay, we can do that.
Okay, thank you.
Thank you, Your Honor.
Cody Mead Irons versus Melanie Gibson.
Court will note the appearance of Ms. Bailey Hobbs on behalf of the plaintiff, Ms. Reed on behalf of defendant. This matter is before the court on the defendant's motion to modify custody, parenting time support, and a show cause in this matter. Ms. Reed.
Thank you, Your Honor. The parties in this matter share one minor child, and that's Paisley Irons, who is 10 years old. We believe that there's been proper cause or change in circumstance to revisit custody, parenting time, and child support in this case, since the last order was entered in March of this year. In the middle of June, my client was made aware that there are allegations that Paisley had been molesting the girlfriend of the plaintiff's son. Is my understanding. It's one of the kids. There was a whole lot of kids involved. And since that time, it's my understanding that the child has not been enrolled in any sort of sexual offending counseling as recommended by the forensic interview. There has been periods where counseling has been stopped completely. It's my understanding that there's been only maybe 1 or 2 counseling appointments with her regular counselor, but during June, July, and the beginning of August, counseling had stopped completely, which is not appropriate for this child. During that time, my client was also not able to communicate directly with the child, as plaintiff had cut off the cell phone for the minor child without informing my client. The plaintiff did not inform my client of the forensic interview when that would be. Plaintiff had misinformed my client about criminal charges relating to the minor child, misinformed my client about a CPS investigation, has refused to co-parent, has refused to allow my client to participate in joint legal decision-making, and has refused to update the parenting app properly with the appointments for the forensic interview, doctor's appointments, and there's just a lot of information that's not being provided to my client. There's not co-parenting going on, and so we believe that the plaintiff is in violation of the order by not providing that information timely pursuant to the order, not allowing my client to communicate with the child until my client started paying the cell phone bill. And we believe that my client should have sole legal and sole physical custody of the child, calculate child support pursuant to the child support formula, immediately enroll the child in counseling for this specific sexual abusive related behavior, have reasonable parenting time to the plaintiff, and that there be a no contact order between the child and plaintiff's prior girlfriend. It is my understanding that they had broken up since this incident, and there has been allegations of domestic violence between this girlfriend and plaintiff's home. So we are asking that the plaintiff be in contempt of court as well and for attorney's fees.
Okay, thank you. Ms. Bailey Hobbs, go ahead.
Thank you, Your Honor. As far as the sex offender treatment, the parties had received a recommendation from the CAC with 2 different therapists named. The parties went forward and made an appointment with one of the therapists. During that appointment, Ms. Gibson became so argumentative and combative that the therapist opted not to provide those services to the minor child. It was a little bit tricky because in order to get the child seen, and it has to be covered by insurance because these parties can't afford to pay for this out of pocket. In order to have the therapist switched from the minor child's main therapist, Mr. Roberts, to the CAC recommended sexual offender therapist, it took a couple of weeks. They had to cancel an appointment with Mr. Roberts, had to have a time frame where the child was not seeing Mr. Roberts. It was approved by insurance. The parties went and had an intake with this, I can't remember her name, but the CAC recommended therapist. After that appointment, that therapist responded, said she's not willing to provide those services due to what happened during the meeting. And then we went back into this, okay, we have got to get this child back into some sort of therapy. We needed a break for insurance to then cover again. So there was about a month, maybe 6 weeks of missed therapy for this child. However, it wasn't on purpose. Like, this kid needs therapy, and I think everybody agrees with that. The child is seeing her regular therapist again, Mr. Roberts. Insurance did approve that again. She began seeing him mid-August, I believe. She sees him every 2 weeks. Miss Gibson has been scheduling the child with Miss Katz as another therapist. My client was informed of one of those meetings. However, Miss Gibson did not inform him of the most recent one, which I believe occurred on the 19th of this month. Any misinformation or information that's not being relayed is, and it's purely an accident on my client's part, but I think it's incorrectly stated to this court. However, Miss Gibson's doing the same thing. My client has never refused to allow the child to see Miss Katz. He thought that a different therapist would be better for the sex offender treatment therapy, because he feels that there's not a great relationship between the child and Miss Katz. But since that didn't work out, he is in agreement with allowing Miss Katz to proceed with that therapy, provided that Miss Gibson can use her insurance to cover those appointments, as his insurance on the child is covering the appointments with Mr. Roberts. Regarding the message for the interview, the forensic interview of the minor child, my client did not know about that until it was going to happen. He knew shortly before he contacted Miss Gibson. Miss Gibson stated that she was on vacation and wouldn't be able to attend. There was no ill will or information not being provided. Regarding the payment of this, regarding the cell phone, Miss Gibson has not paid that cell phone. My client responded to Miss Gibson and told her that he didn't have the money to pay the cell phone right away and that there would be a lapse in service. She denied. He asked her if she could pay for it, and she didn't do that. So there was no purposeful, removing this child from being allowed to talk to her mother. That's all being mischaracterized. And furthermore, all of this happened back in June, July. Why are we now 4 months later saying that this is a huge ordeal? My client thought that the parties were co-parenting fine. He agrees that they don't see eye to eye on everything, but they'd been working together. Regarding the change of custody and the parenting time, it's my client's position that a proper cause or change of circumstance has not been established. Issues regarding the child and her sexual behavior have been brought up multiple times, way before the last custody order was entered. The child has been interviewed by forensically before regarding the same issue. The issue came back up because the minor child admitted to doing it she admitted to her therapist, Mr. Roberts, that it was happening. And so this is not a new issue. It's just now finally coming to light that the child actually can get some help for it. Miss Knight is not around the minor child. The parties separated in July. They have not lived together since. The only time that Miss Knight is even around the minor child, which has been maybe 3 or 4 times, I think closer to 3 is what my client counted, is because Miss Knight and Mr. Meat Irons share a child together. And so the only time that she's been around the child is in Mr. Meat Irons' presence when so she could see her brother. There's no need to enter a no contact order. Miss Knight doesn't even live in the state anymore. She lives in Indiana. Any allegations that the child was treated bad by Miss Knight are untrue. Miss Knight reacted to the news that the sexual behavior was happening, including her child. She reacted, she messaged Miss Gibson. Mr. Meat Irons did not give her permission to do so. She did so of her own free will, but she was upset. That was not said to the kid. The parties, for the short time they were together after this came to light, the parties implemented procedures for the child, for all the children in the house, to keep them safe. So the children weren't allowed to be alone together. If the kids went outside, then a parent had to be with them. Any allegations that the child was ostracized in her own home are completely without merit. Mr. Meat Irons has not violated the order. He entered this appointment regarding the doctor that Miss Gibson cites to in her motion is regarding the child's gastrointestinal doctor. The child has chronic constipation. My client entered it into the Talking Parents app as the poop doctor because he couldn't remember the doctor's name. Miss Gibson knows who that doctor is. Nobody was playing any games. He entered it in as a 9:20 appointment. The appointment was 10 or 15 minutes before that. Miss Gibson wasn't planning on going anyway. She didn't show up, even if it was 10 or 15 minutes later. And she doesn't go to almost all of the appointments anyway. He was not trying to keep her away, nor was he trying to prevent her from having any information. The appointment was regarding the child's constipation. There's no reason for him to play any games with regards to that. Mr. Meat Irons is asking this court to deny plaintiff or defendant's motion, deny that there's been proper cause change in circumstance, order that Ms. Katz is gonna proceed as the therapist regarding the sexual offender treatment until further agreement or order of the court, provided that Ms. Gibson's insurance can cover that. The child should also see Mr. Thomas Roberts on alternating weeks, like she's currently seeing him now. Deny the order for show cause. Mr. Meat Irons is not pursuing a motion for show cause given regarding the appointment that he was not informed of with Miss Katz. He understands that sometimes some things happen, and that, you know, that he's willing to work with her. Deny the motion for no contact with Miss Knight. There may be times where the minor child has to be around Miss Knight for short periods of time to see her brother or during parenting time exchanges for that child. Deny.
Let's wrap it up. I've got a lot of hearings this
Yep.
morning.
I'm all done. I was just going to say deny the request for attorney fees.
Okay. Well, the court notes in reviewing the pleadings in this matter, as well as hearing the argument, that the court does believe that there has been proper cause or change in circumstances sufficient to meet the Varka threshold for an evidentiary hearing. The court will, in fact, schedule that evidentiary hearing after communication with the various attorneys and their schedules. In the interim, the court would order that counseling with Ms. Katz would occur, that that would be submitted to either of the parties, either or both of the parties' insurance. And what the insurance doesn't pay is the responsibility of the parties on a 50-50 basis. The court would order no contact between Paisley and Miss Knight in this matter. That will be the temporary order. I'll ask Ms. Reed that you would prepare that order and submit under 7 days.
Your Honor, we have an FOC hearing regarding modification of support on November 5th. Can we combine those hearings for the judicial economy?
That's fine, yes.
Okay.
You can take that hearing, put it in the order that that hearing is taken off and going to be merged with this.
Okay.
Okay, thank you. Ready to go, have a good day.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff and defendant appearing in pro per. This is before the court on the plaintiff's notice for entry of partial settlement agreement. Clarify for me, Ms. McNiff, I received the defendant's response, and he's saying, I don't agree to the equalization payment. I don't agree to the pension. I don't agree to spousal support or attorney fees. Did you have an agreement at all in this matter?
Your Honor, we went to mediation with Mr. Brundage. At that point, Mr. Rosenthal was representing Mr. Alapade, and we came to a partial settlement agreement at that time. And I put that partial settlement agreement into the form the court has. I emailed that to Mr. Rosenthal on September 4th. I didn't hear back from him until September 12th, at which time he told me that he was no longer representing Mr. Alapade. So we did not agree to spousal support at that point. We agreed to everything else. Mr. Alapade, the court may recall, has been defaulted at this point. The court allowed us to go to mediation in order to try to work out our differences, and we worked out our differences with everything except for the issue of spousal support.
Sir, I don't understand your response when you are disputing, again, the pension, the equalization, attorney fees, if you agreed to all of that.
So, Your Honor, my question has to do with how did they get to the 100,000? During mediation, it was based on the appraiser, and they appraised the house for 226,000. We owe 84,000 on it. If you look at the difference, it leaves at about 140. We divide that in half. I will be owing my.
Okay, sir, I'm not going to get into the specifics of this. If you had an agreement on those issues, that agreement is going to be binding.
We did not. That's what I was trying to explain to you. That the mediation ended when they wanted to tag in additional 42,000 credit card to the 70,000 we agreed to. And I said, no, I'm not going to be paying the debt I wasn't aware of. And that was what led, apart from the default that my attorney did not respond, that led to the disengagement. So we ended mediation abruptly because I disagreed with the 42,000 credit card that my wife accrued without my knowledge. And attorney will be aware of that. So that's why I'm challenging. I'm not saying I'm not, doing equalization payment, but the 100,000 is not even accurate. There was no time we agreed to 100,000. We agreed to the difference in the equity on the house based on the appraiser. The house, and even when I talked to the bank, because I've already started that process, they said they have to reappraise the house because they were not carried along that they overappraised the house. And then with the pension, we proposed that we should, the plaintiff should supply my wife's pension information so that we split that, contingent of that. So, and now in the proposal that Anthony McName is submitting to you, she wants my wife to keep her own pension but split mine. That was in the proposal we had before this engagement with Goldman and Associates. Ditto with the spousal support. We never agreed to that. We said we should have to discontinue the spousal support. She wants indefinite spousal support. So those were my disagreement as highlighted in my response.
I agree that we did not agree on spousal support, Your Honor, and that matter was going to be reserved for trial.
Okay. I do note, looking at Mr. Brundage's report dated September 8, 2024, says partially settled, child-related matters are settled. Property settlement reached at mediation is contingent upon defendant's review of documentation regarding medical debt or marital debt. That's it. So what the court will do at this point is the court will set the matter for a hearing on the issues of spousal support and the marital debt, which appear based upon reading the mediation status report of the only remaining issues in this particular matter. So we will set a hearing date up on those particular issues, and then we'll try that.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
Free to go. Have a good day.
You too, sir.
Summer McKediak versus Mark McKediak.
Court will note the appearance of Mr. Hauser on behalf of the plaintiff in this matter. This matter is before the court on the defendant's motion to set aside referee recommendation. The court at the time that the matter was set did notify the parties that again, in this case, that the defendant would have to appear in person. Mr. McKediak, I'm looking in my courtroom. You're not here in person.
No, Your Honor, I'm at work.
Well, what the court is going to do is the court is not going to hear any motions by the defendant until he appears in person, as this court had previously ordered. So I'm denying your motion at this particular time until you find it upon yourself to appear as I've ordered you in this matter. So that will be the order of the court. You're free to go, and have a good day.
Thank you, Your Honor.
Court will note the appearance of the plaintiff in this matter. This is her motion for show cause, stating that the defendant has failed to return the child since September 30, 2024. Ms. Jones, is that correct? You still have not received the child back?
Well, on Saturday, actually, I ran into them at a restaurant. He didn't notice me. I grabbed Taryn and I did run out.
Okay.
So I got her back this Saturday.
Okay. Well, what's going to happen is in this matter is you file the motion to show cause. So what the court is going to have to do is I am going to have to we'll have to have a hearing on that because obviously we want, you've got her back. The court was going to order that she be returned immediately, but you already have used self-help and you have her returned. So we still need to, at this point, to determine, again, whether he's in contempt. Although it may seem elementary to you that he kept the child, he's in contempt. We still have to have a hearing on that. What I'm going to do is I'm going to refer the matter to the referee for a hearing to address your show cause, as well as to address any, I guess you'd say, any makeup parenting time or any other action in that regard. Okay.
Okay, there won't be any makeup parenting time needed. Actually, I have full rights to her. There's no visitation on his end. That is
Oh, okay.
ordered.
Okay.
So
How did he get the child then?
We actually went through a situation where Taryn, my daughter, had a seizure. When I took her in, she had significant bruising due to 2 different injuries on her face.
Okay.
Social services.
I want to make this quick and simple because I have other hearings. I'm saying, how did he get the child? And you're giving me
Social
you're telling me how to
services.
make a watch.
I'm sorry. I just didn't want you to feel like you were reading between the lines. So social services asked me, would it be fine if she stayed the night with him for the night until my home was cleared? I okayed it. CPS cleared me. I went to pick her up. He refused to give her back.
Okay, got it. Okay, well, it looks like things are taken care of. If he wants other parenting time, he can come forward and file a real appropriate motion. But sounds like again, the self-help has worked. So thank you, ma'am, and you're free to go. Have a good day.
Will there be a further hearing?
No, I won't need it now that what you've mentioned and clarified.
Okay, thank you.
Thank you.
Yep.
No evidentiary hearing?
No. This matter is before the court on the plaintiff's motion to set aside referee recommendation. Ms. Isaac, I'm looking at the paperwork from the file, and it shows that basically you were served at your Marshall, Michigan address in this matter. You said you didn't receive them, and obviously that may happen. It happens sometimes with the mail service, but other than that, what is the legal or factual error that the referee made in this matter?
He's wanting to dismiss it because I wasn't in court, but I'm the one that filed the motion for my children because I've been lowered my hours at work, and Paul's been working and he hasn't been helping us at all. And my kids have been going without. Some days I don't even know if they're going to have another meal. So for me to miss a court, it's not right. I would not have missed the court for my children.
Okay. Well, what I'm going to do, ma'am, just obviously to get this back before the referee is, obviously I was going to have you refile a motion, but if I have you refile the motion, it's just going to get back to the referee anyway. I'll refer the matter back to the referee. We'll set up another hearing, and then you can appear at that point and present your case. Okay?
Okay. Thank you.
Thank you. You're free to go. Have a good day.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Mr. Umlauf on behalf of the defendant. This matter is before the court on the plaintiff's motion to enforce judgment of divorce. Ms. McNiff.
Your Honor, we were here before last week and the court adjourned. This issue is primarily, the only issue is Dad has not been paying for his portion of the child's college expenses. I've read Mr. Umlauf's motion, and in response, we would tell the court that Mr. Dubiel has had access to the child's tuition statements. My client made sure that he had access. We don't believe that he has set up an account, but that would be on him to do that. He was sent an invitation. I sent that information over to Mr. Umlauf early this morning. He may not have had a chance to look that over. We also have sent Mr. Umlauf a copy of the 529 account. The 529 account only has about $4,000 in it, and it was my client's plan to save those funds until the child's senior year when expenses would be heavier. $4,000 isn't very much. It's not going to pay for her college education. It may cover part of one semester. But at this point, the parties have a deal. The judgment is very clear that they're to share those college expenses. The child is going to Northern Michigan University, which is one of the less expensive universities, public universities in the state. And we're simply asking that the court enforce the parties' agreement.
Okay, thank you. Mr. Umlauf? You're muted, Mr. Umlauf.
Apologies, Your Honor. I didn't realize I was muted. I have not seen the email that Lisa sent me, so I haven't had a chance to review it. As it relates to the expenses, my client has not been has not had access to a good portion of the information that the plaintiff has had access to. He has only been provided verification for the books and the enrollment deposit. He has not been able to see any of the other supposed expenditures, and we are asking that verification be provided. If some sort of link was sent to him to allow him to sign in, he either didn't see it or didn't understand what it was when it was sent to him. Furthermore, there is a 529 account with approximately $4,000 in it per the information provided by the plaintiff. We haven't seen an actual statement yet. As I understand it, Lisa sent it to me, but I haven't read it yet. But we would ask that that be used first before the parties have to spend any of their own money on the minor child's college education. And finally, Your Honor, this is a situation where my client has not been involved in any dialogue with either the plaintiff or the minor child regarding her college education. And so he has really been, in essence, the only dialogue that he has had is receiving emails from the plaintiff requesting that he pay the bills. My client understands that he should pay that he's required under the terms of the judgment of divorce to pay for half of the minor child's college education, but we are asking that verification of those expenditures be provided to him before he actually be required to pay them, rather than simply taking the plaintiff's word for it. Thank you.
Thank you. Well, what the court's going to do in this matter is, it doesn't seem, if the child has a 529 plan, it doesn't seem reasonable. The child just started that we're just going to wait until the child's senior year to utilize that. So the court would order that any amounts in there would be utilized first in this particular matter, that any balances after the utilization of that would be again paid for in this case. So by the parties equally as per the provisions of the judgment of divorce. So I don't know how much is in there or how much you're going to have to, Ms. McNiff, figure that out, apportion it to the, I guess, to what's been paid at this point. And again, the defendant would be responsible for his 1/2 the cost of that. And I'll let you, Ms. McNiff, provide Mr. Umlauf with the amount that is due. The court would order that he would pay that amount forthwith. And that, again, the plaintiff would provide any, I guess, re-provide him with that link to get into the account so that he can view that or see what the expenses are, et cetera. Further, that she would provide the verification of the expenses that she had paid and then what the amount is owed to him. And then the court will reserve on any attorney fees or costs in this matter. So, Ms. McNiff, you can prepare that order and submit under 7 days.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day. Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion to enforce order, basically for a counseling, assessment, et cetera. Ms. Reed.
Thank you, Your Honor. I think some of the issues have been resolved. I received an answer to our motion from the plaintiff this morning, and it looks like the evaluation of Dr. Haugen was completed on the 17th of this month. Since Ms. Burdick is retiring, we're requesting that the child engage in any counseling or as a counselor as recommended by Dr. Haugen. And they are requesting a communication app such as App Close, Talking Parents, or Our Family Wizard, as my client would have known about this had plaintiff been communicating, but she just doesn't. And I know the phone number that we have in our office for the plaintiff is disconnected, and parties really need to communicate about this 15-year-old child. So if she's not willing to do phone communication or letters or emails, a communication app is appropriate.
Okay, thank you. Ms. Ione, in this matter, do you have any opposition for the child engaging in counseling with a counselor recommended by Dr. Haugen?
No, I do not have any opposition to that.
Okay.
I'm fully, okay.
The court will so order then if there's no objection, and that the court would order that the parties would communicate through app close. So you'll have to contact them to set up an account so that you can communicate. Anything else?
No, Your Honor.
Okay. Okay, Ms. Reed, you can prepare that order, submit under 7-day, and you're free to go. Have a good day.
Thank you.
Thank you.
Thank you.
Court will note the appearance of Ms. Henderson on behalf of the plaintiff, Mr. Hollick on behalf of the defendant in this matter. The matter is before the court on the plaintiff's motion to clarify provisions and various other relief as well. Ms. Henderson.
Good morning, Your Honor. The parties were able to reach a partial agreement that I will read into the record. So we only have 3 matters remaining for the court to decide today.
Okay, go ahead.
First of all, the parties shall notify each other of any out-of-state travel, including location and dates of that travel. Further, neither party shall deny the reasonable telephone or video contact for the minor children with the opposing parent and shall ensure the children's participation in those phone calls. Third, the parties shall be prohibited from smoking marijuana, tobacco, or vaping around the children in the vehicles or inside the home, and that would also apply to significant others of the parties. Fourth, the parties shall use app close or other similar app for communication regarding the minor children. Fifth, each party shall be entitled to a video or telephone visit with the minor children on the party's respective birthday if their regular parenting time does not fall on that day, with a 7-day notice to the other parent, and in order to agree for the time for the call. 6, neither party shall disparage the other party, their family members, or significant others in front of the children. Each party shall foster a continuing relationship with the other party, and the party's family members and their significant others shall refrain from making any disparaging comments about the other parent, especially at parenting time exchanges or in other situations where the minor children are present. Those issues are agreed upon, Your Honor. The only 3, one more issue, the plaintiff shall have a spring break in odd numbered years and defendant in even numbers years. So that will coincide with what the parties have actually been doing. So the 3 remaining issues, Your Honor, are the clarification on the beginning of spring break and winter break. That issue has been brought up by the fact that most school calendars state that spring break is from Monday to Friday of the actual week. However, the order of the parties currently states that spring break or winter break start on the last day of school at 6 p.m. and they end at 6 p.m. on the last day before school resumes, which is in congruence with the FOC schedule currently in place in Calhoun County. And the reason for that is parties frequently travel during those breaks, and having that weekend parenting time would also add to the quality time the parties can spend traveling. There have been multiple discussions with the parties where defendant insists that those breaks start when the school calendar says, rather than the order. And we're just asking for the court to clarify what the parties should follow. It's our position that the order should control, and the order states it's at 6 p.m. on the last day before, or the last day the school is in session for the children, and then it ends at 6 p.m. on the last day before school resumes. The other issue.
Hold on. Let me get Mr. Hollick's.
Sure.
Mr. Hollick, as stated by Ms. Henderson, is that the agreement that you have concerning those particular issues?
We have an agreement on the issues, aside, of course, from the when exactly winter and spring break start.
Okay. Anything else, Ms. Henderson, besides that issue?
Yes, Your Honor. The second issue we would like the court to weigh in on is in the current order of the parties, each party is entitled to 1 week of vacation with the children in the summer. And the way that defendant has exercised that is he takes my client's week, and then he essentially exercises 3 weeks of parenting time in a row. And we're asking that the court either limit
Okay,
that.
go to the
neither-
next issue, Ms. Henderson. I know what that is, so.
Okay, and the third issue, Your Honor, we're asking for the Sunday parenting time, exchange time be switched from 7:30 p.m. to 6 p.m. Given the fact that it takes the children a long time to wind down and get ready for school, which pushes back their bedtime, and we're asking that the exchange occur at 6 p.m. instead of 7:30 to promote sufficient rest for the children, Your Honor.
Okay. Mr. Halleck, what on those final three issues, what's your response?
Well, I'll start with the comp day, Your Honor, and the order says that, and I'm reading directly from it, it is further ordered and adjudged that the spring, summer, and Christmas vacation periods shall be determined based on the school district in which the children attend school. So they go to Penfield schools, and prior to spring and summer break, I have the school schedule in front of me. It's November 27th for Christmas break this year, and then March 28th for spring break this year. The children have a comp day the last Friday prior to break. It is clearly labeled as a comp day. It's not part of the spring break. It's my understanding after discussion with my client that each of the parties have basically kept the children on that day with no school when it falls on their parenting time. So some years it's with my client, sometimes it's with Ms. Henderson's client, and it's not part of spring break, and my client wishes that to proceed. It's our understanding based on the reading of the order that the spring break is defined by the language and by the policies of the school. And it's clear that the school here does not label these days as part of spring and summer break. They're comp days, therefore they should not be treated as part of spring or summer break.
Okay, go ahead. So any other response on the other issues?
Yes. Moving on then to the issue of the
Next issue is the weekly time in the
Yes,
summer
well,
and the Sunday exchange.
yes, and my client has informed me that frequently the parties have traveled down south, especially my client. They take extended vacations, and this week is used for that family vacation that he takes with the children. It's further my understanding that both parties have availed themselves of this option to take that week and basically create a 3-week block of time with the children. My client wishes that to continue. He has by no means been the only one utilizing this type of exercise of parenting time. He sees no problem with it. The children seem to enjoy it, and he would like that to continue. Finally, the parties in this case live less than 5 miles apart by MapQuest. I checked it, Your Honor. And the proposal by the opposing side would essentially deprive my client of an hour and a half of parenting time every other week with no benefit to him. He wants to spend as much time with the children as possible. There's no hardship to the children by allowing the parenting time to take place at 7:30, considering the parties live, figuratively speaking, a stone's throw from each other. So he does not wish to simply give up an hour and a half of parenting time with the children for nothing.
Okay, thank you. Well, what the court's going to do is obviously we have a judgment in this particular matter. The court will enforce the judgment. The judgment states that the spring break, the summer, and the winter fall on the last day that school is in, based on that. So the court will have, again, that parenting time or start on the last day of school through the time that the school recommences at the end of those particular holidays. As it relates to the Sunday exchange, the judgment, which is a consent judgment, provides that that would be at 7:30 p.m. It'll remain at 7:30 p.m. as per the judgment. As to the 1 week, again, there was no intent when the court grants that one week of particular parenting time. That's so that they could go and it would be uninterrupted by midweek or anything of that nature. Not that a party would have 3 consecutive weeks. So again, if he's taking his uninterrupted week, it would be during his time for his weeks, not during her week of parenting time. With that, Ms. Henderson, you can prepare the order and submit under 7 day.
Thank you, Your Honor. Just to clarify, so the court is following the general provision that breaks start at 6 p.m. on the last day of school, not, you know, as it states Monday through Friday. Is that, am I
Correct.
understanding you correctly?
Correct.
Thank you. Thank you, Your Honor.
I apologize. The court broke up. Could you repeat that, Your Honor?
Yes, it's the school schedule. It's at 6 o'clock p.m. on the date that the school ends. Okay, thank you. Free to go.
Thank you, Your Honor.
Thank you, Your Honor.
Shania Roman versus Sebastian Roman, attorney Moss for plaintiff and Todd for the defendant.
What issues do we have with the Romans?
I believe. Go ahead, Wes.
Yeah, I was just going to say probably the same thing. I think at this point, mark everything. We haven't necessarily had a great opportunity to speak, but I think everything at this point.
That includes spousal support?
I don't believe so.
I don't think spousal
Okay.
support.
Then it's not everything, Wes.
Yeah, true. Almost everything.
If I check that, you'd be stuck with that.
That's
So,
true. That's true.
okay, are you gonna need discovery, it sounds like?
Wes, can we do the, what's the form, CC 320? Do you usually do that standard?
Mhm.
I think that will take care of a lot of it, but maybe we should have just minimal discovery.
Sure.
Anything else?
That's fine.
December 1st or January 1st?
January, please.
Okay. Okay, we'll send it to mediation in January. Who would you like to mediate it?
You want John, Hannah?
I would love that.
Okay. You want Kelly as an alternate?
Yes, I do. Look
Okay.
at, this is gonna go so smoothly.
Perfect.
Yeah, just wait. He's just lulling you is all.
Yeah.
Yeah, you'll just think, oh, well, Todd's a really nice guy and he's just, hey, I get along with him, everything, and then
Oh.
they'll just rip
Yeah.
out the throat, you know?
I know he can turn into a vicious advocate.
Oh, yeah, yeah. So you've got to watch yourself. Okay, we'll come in February 10th for a settlement conference. Parties are required to be present unless you've come to a full resolution prior to that time.
Great.
Anything else that we can do for you?
Not that I can think of.
Okay, we'll send this out. You'll get it here within a week and we'll let you go. Have a good day.